20 years after the 2006 Malegaon blast killed at least 31 people and injured hundreds, the Bombay High Court on April 22nd ruled that the case reached a dead end because of contradictory, irreconcilable and diagonally opposite actions by the two investigating agencies. This effectively means that nobody is on trial right now for the blasts, even after the case was investigated by separate agencies, the Mumbai Anti-Terror Squad ATS first, then by the CBI, and lastly by the National Investigation Agency or the NIA. You're watching The Print and I am Ruchi Bhattar. Let's break down how we got here 2 decades later and how the 2006 case involving 4 bomb blasts on September 8th, moving through multiple hands and sharply divergent investigative theories, both of which now cannot be reconciled by any stretch of imagination according to the High Court. A division bench of Chief Justice Sri Chandrasekhar and Justice Shyam C. Chandak on April 22nd discharged all 4 accused, namely Manohar Navaria, Rajendra Chaudhary, Dhan Singh and Lokesh Sharma, saying there was insufficient evidence to proceed with the trial against them. Most importantly, with all accused acquitted, this leaves the most basic question unanswered. Who was behind the 2006 blast that killed 31 and injured many? Crucial to note, this verdict comes almost a year after a special NIA court acquitted all 7 accused, including BJP's Pragya Thakur and then Colonel Prasad Shrikant Purohit, in the 2008 blasts, which happened on a Friday afternoon during Ramzan and the eve of Navratri, which also happened in Malegaon and put the idea of saffron terror and alleged Hindutva extremist network under the scanner. The probe for the 2006 blasts, started by the Maharashtra ATS, later backed by the CBI, accused the member of the banned Students Islamic Movement of India. However, when the NIA took over the investigation in 2011, it advanced a completely different theory of conspiracy, which it claimed was based on confessions and its broader investigation. This shift, coinciding with the changing politics at the center, left the prosecution between 2 mutually exclusive versions. This, the Bombay High Court said, ultimately weakened the prosecution's case to the point where neither could sustain a trial. Let's look at the original narrative of the ATS and the CBI. The ATS theory of 3 blasts at Hamidiya Masjid, Bada Kabristan and Mushawarat Chowk of Malegaon was that they were a conspiracy by the members of banned organization called SIMI, who, according to the squad, had pre-planned the attack at a meeting in May 2006. It was alleged that they formed an organized crime syndicate and committed illegal acts in a conspiracy with an object to promote insurgency and overthrow the government. The allegations also involved the accused SIMI members visiting Pakistan in 2003 and receiving terrorist training there. Supporting this claim, they also said that the explosive bomb material, RDX, was procured by the 2 of the accused and bombs were prepared in another accused's godown. Even after the CBI took over in 2007 and filed a supplementary charge sheet in 2010, it corroborated the ATS's findings and backed it with forensic voice samples of conversations intercepted by compact discs. The diagonal shift by the NIA's theory comes in now. In April 2011, when the NIA took over the investigation following a central government order and filed a supplementary charge sheet in May 2013, it completely discarded the findings of both ATS and the CBI. Departing from the earlier focus on alleged SIMI members, the NIA put forward a new theory of a conspiracy by a different group and named a different set of accused, including those discharged by the Bombay High Court order recently. This new angle was based on a confession by Swami Asimanand, an RSS activist who later retracted his statements. In his confession, Asimanand said that Sunil Joshi, who's also an RSS activist, had told him that the Malegaon blasts were the handiwork of his boys. According to him, it was proposed in a meeting in June 2006 that the Malegaon may be a suitable place which has 86% Muslim population, and Sunil Joshi assured him that during the Diwali festival, his persons would cause bomb blasts in Malegaon. End quote. The NIA also said that the first set of accused had retracted their confessions as they were obtained by the ATS under alleged duress and pressure. Crucially, the Bombay High Court noted that the NIA's version was built largely on the retraction in statements, which is impermissible in law, and new spot identifications made years after the 2006 incident. How did we reach the dead end? The Bombay High Court highlighted the intrinsic improbability of the prosecution's shifting stance. Some major investigative discrepancies identified by the High Court were how the ATS claimed that Muhammad Ansari was a planter, while the NIA claimed that he was 400 kilometers away from the bomb site on the day of the blast. Another inconsistency identified by the High Court was how the ATS alleged that one of the accused purchased the bicycles used in the blasts, whereas the NIA claimed that the appellant Rajendra Chaudhary, who's also one of the 4 accused discharged by the recent High Court order, purchased them under a false name. The High Court pointed out how the materials collected by the NIA to show how accused purchased bicycles on which bomb was planted were actually hearsay evidence. It regarded how the NIA knew that the bicycles were purchased and used in the crime by the first set of accused by the ATS and CBI, yet the NIA projecting an entirely different story and completely ignored the ATS's charge sheet. The court also questioned how the NIA could ignore forensic reports collected by the ATS that found RDX traces in the soil of the first set of accused go down. The court said that there was no explanation coming forth as to how the voice samples and FSL reports collected by the ATS and CBI, which were opposite, can be ignored by the court. It said that evidence collected by ATS remained on record and had been considered by the trial court. There seems to be no answer in law as to how the trial judge can deal with the materials collected by the ATS which implicates another set of accused persons. The court also said that the case seems to have reached a dead end. Criticizing the special judge's September 2025 order framing charges against the 4 individuals, saying that the judge had acted as a mere post office and did not apply his mind before framing the charge against the accused person at the behest of the prosecution instead of sifting the evidence to find a prima facie case. The High Court also emphasized that a test identification parade or TIP conducted by the NIA 6 years after the incident had no probative value. Furthermore, it ruled that much of NIA's evidence was hearsay or based on inadmissible custodial statements. Quoting Supreme Court precedents, it said, "A criminal trial is not like a fairy tale where one is free to give flight to one's imagination and fantasy." The judgment concludes that because the ATS investigation, which implicated the first set of accused, was not wiped from the record, and the NIA version implicating the second set was inadmissible and contradictory, the prosecution has reached a point where no one was left on trial for the 31 lives lost. With that, thank you for watching.